Hello, everyone. Thank you for joining us in our complimentary webinar series for U.S. federal government contractors. We're coming to you live today from Washington, D.C. You probably found out about today's webinar through our newsletter, which reaches over 23,000 federal government contractors and service providers. Today's session is complimentary and also recorded. You can find the recording on our website and YouTube channel about 24 hours after the webinar, though usually even sooner. We have over 500 complimentary webinars on our YouTube channel. This includes all 52 parts of the FAR, all 52 parts of the DFARS, and hundreds of webinars on strategic and tactical topics. If you'd like to advertise in our newsletter or in any of our upcoming webinars, please email us at hello@jenniferschaus.com. Okay, and a little bit more about us. We are a specialized consulting firm focused on working with established federal contractors. We work with product, service, and software firms across the globe. For more information about our services, please visit our website and select About Us. As mentioned, today's webinar covering the FAR supplements is complimentary and recorded. We began this series in January 2022, and you can find the past recordings on our website, as well as the future schedule with registration links. And here's just a look at our schedule. As you can see, we are almost done with this series. We'll be winding down this series on August 24th with the Department of Veterans Affairs. And then here's just a look at our Friday schedule. On Fridays, we cover the same agency or department in a playbook series. The Friday webinars discuss upcoming bidding opportunities, contracting trends, small business resources, and they often feature a government speaker. So the full schedule for this and past recordings are also on our website under the Playbook tab. And please note that this fall, we will be starting a new webinar series covering subcontracting opportunities in the different government departments. These webinars will be on Wednesdays at 12 p.m. Eastern, and they begin September 7th with the Department of Agriculture. Again, registration links and full schedule on our website, this time under the subcontracting tab. Now, we would like to thank our sponsors who make this webinar series possible. First, we'd like to thank the Virginia PTAC. Virginia PTAC is based out of GMU in Fairfax and offers free one-on-one counseling to firms in Virginia on federal, state, and local procurement topics. Online resources and group trainings are free with no restriction on business location. If you're interested in learning more, please use the links provided to explore what PTACs can offer. And a special thanks to the Federal Business Council. The FBC creates and manages virtual and in-person meetings and events to connect industry and government thought leaders, product providers, and solutions with government programs that use them. The FBC works with a variety of federal agencies to connect government and industry in the form of in-person and virtual conferences, training events, policy dialogue, and outreach. Over the last 40+ years, the FBC has become a comprehensive resource for connecting industry and the federal government. Next, we'd like to thank Dastin. Dastin is an IT and cloud solutions provider working with corporations, the military, and government agencies to lower their costs, increase scalability, improve operational efficiency, and meet compliance regulations using targeted cloud-based solutions. Dastin is a certified partner of Oracle NetSuite, a premier tier Google Cloud partner, and certified partner of Cisco, Virtue, AODocs, and Authenticate. For more information about Dastin services or to schedule a complimentary consultation, please email Joe Alston or visit the Dastin website. Next, we'd like to thank C3. C3 ISIT develops tailor-made technology solutions that increase efficiency, bolster productivity, and improve business processes. C3 is the leading provider of managed IT services, as well as compliant cybersecurity solutions for federal contractors. C3 works with defense contractors to achieve and maintain CMMC 2.0, DFARS, and NIST 800-171. Contact C3 to learn about the CMMC 2.0 Readiness Program. The contact information is on your screen. Next, we'd like to thank RLJ Financial. Founded in 2008, RLJ Financial Consultants is a customer-focused, quality-driven, minority and locally owned provider of commercial insurance brokerage services. Their services are designed to maximize your return on investment and managing the risk to your business. Call Roderick today at 202-832-1417 for a free consultation and insurance quote. And lastly, we'd like to thank the PubK Group. The PubK Group publishes news and insights for government contractors, agencies, and counsel. Every day, PubK delivers news on bid protests, contract disputes, new laws and regulations, cybersecurity requirements, False Claims Act activity, and developments in mergers and acquisitions in the GovCon community. In daily news briefs and in-depth conversations and podcasts and webinars, PubK leverages its deep bench of government contract experts to keep you up to date on fast-changing government rules and expectations. And every January, PubK presents its week-long annual review, featuring more than 50 GovCon experts across a dozen panels, recapping the year's top developments. Participation and CLEs are free to subscribers. Visit PubK online at www.pubkgroup.com. All right, and thank you again to the attendees and to our speaker for joining us today in the FAR Supplement series. And today we're all here to dig into the FAR Supplement on NASA. So let's meet our speaker. Our speaker today is Eric Crucius, and he represents the firm Holland & Knight LLP. As a reminder, we don't take any questions, so if you have any questions for Eric, his contact info is on the screen. Thank you again for joining us, Eric. I'll put myself on mute. The floor is yours. Just let me know when you're ready for the next slide.
Thanks so much. It's really good to be here, and you could go to the next slide. That way I can stop staring at my picture on the screen. So we're here to talk about the NASA FAR Supplement. If you've been listening to the series and are familiar with government contracting, you know we have the General Federal Acquisition Regulation, which was, aimed at streamlining government procurement. And then lo and behold, subsequent to the establishment of the FAR or thereabouts, we had other agencies adding their own specific regulations that laid on top of the FAR. And most agencies got into this game, including NASA, which has a pretty robust FAR supplement. They do about this year, there's about $24 billion in budgetary authority for NASA in fiscal year 2022. They're requesting about another billion from that more for next year. So there's plenty of contracting opportunities. So it's not surprising that that NASA has some fairly specific regulations. You could look into, we could spend the day kind of looking into the NASA FAR supplement. It's 638 PDF pages long. So I was told to keep it to about a half hour. So we're not going to cover everything that's in the NASA supplement, but we'll try to hit some of the highlights that I think would be of most interest to this audience. In any event, I'm sure there will be topics that are out there that we're not covering because it's just physically impossible to cover a supplement like that in probably less than a day fully. But hopefully this will give you the highlights and kind of help raise awareness of particular issues that you may find. But with any kind of regulations, you want to look to your contract, look to the solicitation to know which regulations, whether it be FAR, whether it's the NASA FAR supplement, whether it's another agency clause. How do you know that it's applicable to you? It's by looking at the solicitation of the contract. Of course, nothing in life is ever that easy, like the rules we have for grammar. There's always exceptions to the rules, and here there is one too. We have something called the Christian doctrine, of course, which is not a religious doctrine, but is based on a case called GL Christian and Associates, which stands for the proposition that there's some clauses in government contracting that are so ingrained in government contracting that they're not, even if they're not there, they're going to be read into a contract. I would be surprised if any FAR supplement, NASA FAR supplement clause is in there as a Christian doctrine clause. So I think it's fairly safe to look at your contract, look at the solicitation, and if the NASA supplemental clause is not in there, then it's probably not, at least the agency at that time doesn't believe it's applicable to the contract that you have. That being said, the NASA supplement itself is pretty diverse. It covers a lot of procurement topics. So we're going to go through a lot of different topics today. And you'll see kind of a little bit of the structure of it based on how we've pieced together these slides. We go to the next slide. So there are different subchapters in the NASA supplement. It goes from A through I. Really, B through F or G is where the meat of this is. But I think it's still important to kind of note these other parts too. So within the subchapter, there are parts, as you can see, and below. So each one of these slides is laid out the same way. The subchapter of the supplement is noted on the top. The parts that subchapter covers is also noted on the top. And then immediately below that is the title of the subchapter, the topic of the subchapter and the parts inside that subchapter. So kind of it's a good waypoint, and you could see where you are based on that. Again, I'm going to try to point out the differences between the NASA supplement and the FAR, or even where there are similarities, but they're interesting. Point those out as well. But this is kind of a housekeeping section of the NASA supplement. Now, I think one of the most interesting parts of the FAR is the part where there are all the definitions, because really the definitions control how you read a lot of the clauses. There are definitions in the NASA supplement also. I didn't think any of them were kind of interesting enough to warrant inclusion in the slideshow, but you should know that there are definitions. Most of the definitions kind of have to do with the people administering procurement within NASA, their titles, and where you go for certain things. So if you're unsure if you have a question or an issue and you're unsure who to go to, you could look at the NASA supplement definitions, and that may give you an idea of who best to reach out to with any questions or thoughts or anything else. So the subchapter A itself talks about how the NASA supplement can be amended, and also talks about class deviations. Now, I think a lot of you know what class deviations are, but for the uninitiated, in general, what they are is that if there is a regulation that's out there and the agency wants to change something in some way, shape, or form, or there's no regulation at all, the agency needs to announce a new policy that will be in contracts. The proper course of action is to go and put out a proposed regulation, get comments, put out a final regulation after the comments are considered, and have that kind of be what the regulation is. Sometimes situations are emergent and they don't allow for that regulatory process. Even if that regulatory process is short-circuited a little bit by the agency issuing a final interim rule instead of a proposed rule. So normally there's a proposed rule which is not impacting anybody at that time, where they get comment. Another option that agencies have is that they can issue a final interim rule without a proposed rule, which means, hey, this rule is on you now, you have to comply with it, but we're going to still take comment and issue a final rule, which may change the final interim rule. That's not a great scenario for contractors, because they come without warning or little warning usually, and they don't reflect feedback from the industry in general. When I say the industry, I mean not just contractors, but other interested parties, even folks in the government, or folks working on the contract, are not given the ability to comment on the final interim rule before they're issued. Now, even more emergent are these class deviations, which happen sometimes in response to a National Defense Authorization Act requirement or some other statutory requirement. Sometimes a situation like with the pandemic, where a lot of agencies issued class deviations to implement regulations requiring vaccines and other health and safety measures. Now, without saying whether that was the right thing for them to do or how I feel about that policy, a lot of those regulatory requirements have been put on hold by various courts. It remains to be seen how they will net out, but it is held up by the courts right now. but that was off of a class deviation essentially. So class deviations are there because they allow flexibility from the agency, but they also don't allow consideration by the general public before these requirements are put in, but they have the same force and effect essentially as a regulation. So you can see here how NASA kind of talks about their authority to issue temporary class deviations. You can see they say since they are processed and issued without public comments, they should be used very carefully and for a specific duration that is sufficient to allow for the formal processing of change to the FAR and/or NFS. And it talks about who's in charge of issuing those. And if you are curious what kind of class deviations exist right now, and just the class deviations, you could look at the NASA procurement library. The NASA supplement, which is available online in PDF form, notes where there are class deviations as of July 1st, I believe is the latest update, 2022. So you can look at the NASA supplement and probably be okay. If there is a specific provision that you're interested in, I would also go to the NASA procurement library and make sure there isn't a class deviation that was missed and not put in the supplement or made since the supplement was issued. Let's go to the next slide. So Subchapter A, some more kind of housekeeping things that we should note that I think are important here. The first is they talk about antitrust, and there's a quote in there: when there's reason to believe that 1803.303 is a reference to the supplement itself. When there's reason to believe the offers may not have been arrived at independently, contracting officers should submit reports of potential antitrust violations. If you remember, in October of 2019, it was announced in November, but really October 2019, DOJ stood up what's called the Antitrust Strike Force, and they've had some recent successes where the DOJ's theory is that there's a lot of antitrust shenanigans going on in government procurement, whether it be on the federal or state level, that contractors are coordinating with each other in bid rigging and et cetera, et cetera. Not that it's widespread, but there's enough out there that they need to address it. And, from a personal perspective, I haven't really seen it, but again, would I be in a position to see that? They've had some recent successes. So here's just a sampling of cases that are out there. And it's a good reminder about kind of the types of things that can be looked at by the Antitrust Strike Force, and with reference to this NASA FAR supplement 1803.303 provision. US versus Quan, which is from March, these are all from this year. There was bid rigging for repair and maintenance contracts at US military installations. Dornsbach was a concrete company, and the CEO is indicted for big rigging concrete contracts for a period of about 5 or 6 years. US versus Leverett, they bribed government employees and rigged bids falsely and falsely held. The defendant was falsely held out himself to be eligible for set-asides. And then Investicom, defendants created kind of stalking horse bids that were hired to make the Investicom bid look better. So those are 4 examples of kind of bid rigging that DOJ, where they've pursued and gotten indictments recently over the last 6 months or so. So you could bet that this provision is something that you should pay careful attention to, and if you have them in your NASA supplemental contracts. Another thing to keep in mind also, 1852-203-71, contractors have to tell employees of their whistleblower rights, and this must be flowed down to subcontractors also. It's probably good practice anyway. There are new regulations also coming out that would add to this. They're not NASA supplemental regulations, and honestly, I think they're FAR, but they may be DFAR reg, but that will prohibit contractor employees from entering into NDAs with their employers that prohibit them from reporting waste, fraud, and abuse. So again, this is kind of all in the line. Employees should be free to kind of talk to government agencies if they see something, and this one in particular requires the contractor to tell their employees of those whistleblower rights. Next slide. This is a big one here, cybersecurity. Obviously, there's a lot going on in this area. We have CMMC 2.0, the Cybersecurity Maturity Model Certification Program ramping up. We have a DFARS clause 252-204-7012, which is with the defense supplement. We have a FAR clause as well. All of these cybersecurity clauses plus other individual agency clauses have created a patchwork of requirements for government contractors. If you're in the government contract space and you're working with a number of different agencies, you're going to find that you have different cybersecurity requirements depending on which agency you're working with. DoD has its requirements, which are fairly significant even now, which requires compliance with the 110 controls that are part of NIST Special Publication 800-171, as well as informing DoD of a cybersecurity breach within 72 hours and cooperating with DoD investigations into cybersecurity breaches if you have controlled unclassified information. CMMC 2.0 is coming out, which will require a third-party certification for contractors, for almost all contractors that have controlled unclassified information as part of their government contracts. There are other clauses out there, 252-204-7019 and 7020, which do require contractors to put in their compliance with NIST Special Publication 800-171 to the Supplier Performance Risk System, or SPRS. How many of those 110 controls are they compliant with? Of course, be careful of inconsistent certifications. If you've had the 7012 clause and you're doing business with DoD and you've been performing those contracts, you've been taking that clause, that is, DoD may view that as a certification that you're compliant with NIST, whereas the 7019, 7020 requires you to kind of enter that compliance into a system. DoD is auditing contractors actively who say that they're compliant with the 110 controls to verify that, and they're seeing a lot of instances where contractors are not. And now we have this third-party certification. On top of all that, we have this NASA supplemental clause, which is not that old. It's just a few years old, and it's 1852-204-76 that deals with controlled unclassified information. If you look at the clause itself, they have a different term for it, but there is a class deviation that changes it to controlled unclassified information. And it's required when performance contractors will have physical or electronic access to NASA's computer system networks or IT infrastructure, or, this is a big or, when the contractor uses information systems to, quote, generate, store, process, or exchange data with NASA or on behalf of NASA, regardless of whether that data resides on a NASA or a contractor's information system. Pretty broad there. And you can see there are two major requirements that are part of this clause that are a little bit more than what you find in the DFARS clause, although you are required to have an IT security plan with the DFARS clause as part of one of the 110 controls within NIST 800-171. So you have to develop and implement an IT security management plan, which really focuses on the people and the processes within a company. And then within 30 days of award, there's also a requirement to develop an IT security plan. And on top of that, if an employee of the contractor is requiring access to that IT security system, then they'll have to also take NASA's annual IT security awareness training. And on top of that, NASA has broad rights under this clause to access the systems physically or electronically of contractors to audit compliance with these requirements, and in general with cybersecurity requirements. And for instance, they can, and it's mentioned right there in the regulation, they can conduct vulnerability testing. So, this really is a significant regulation for, as far as cybersecurity is concerned. It's more than other agencies, maybe with the exception of DoD is requiring. So if you do have contracts with NASA, you should pay close attention to this. Next slide. Okay, we've moved on to B. And Subchapter B deals with parts 1805 to 1812 and concerns competition and acquisition planning. So this largely mirrors, this first bullet point largely mirrors the FAR. And in general, the default is for competition, of course, but there are certain circumstances where competition is not required. And this kind of lays that out a little bit. Part 1806 talks about where non-competitive proposals are allowed. kind of the also talks about, who has to approve it and how and when and all that kind of stuff. So, very helpful perhaps during a bid protest process where there's been a non-competitive proposal and you allege that there's not been the right approvals. You can kind of look to these regulations and see what kind of approvals are necessary. One thing, that at least I've had bid protests on in the past is consolidation and bundling, where an agency, for ease of use and maybe just to allow for more seamless integration of systems and stuff, they bundle requirements together. That, of course, hurts small businesses, which are not in not as good a position to provide responses when there's a bundled or consolidated solicitation, because they're not quite big enough or don't have the past performance to really to work on contracts like that, sometimes, at least in the government size. So here, if you have bundling of some kind, there are requirements to have that approved. And also this section looks at responsibility, and you could see if they're awarding a contract worth 500 million or more, and it's really for systems and things like that. There needs to be a responsibility assessment through a financial capability assessment run by NASA before the award is actually given and performance can start. So that's something to just keep in mind. Also, sometimes products have to be qualified before they're used by an agency. First article testing, things like that, samples. So that requirement under this section can also be waived when acquiring a product under a specification. You can see here there are certain circumstances where that can be waived. And if you look at 1809-406, suspension and debarment is talked about in great detail in that section of the FAR NASA supplement. Next slide. So just kind of a little taste of that. You could see here how NASA kind of will work a suspension debarment procedure. I mean, suspension debarment's interesting because it's handled a little bit differently by each agency, but they all recognize each other's outcomes for the most part. And then you have a different process at the Department of Labor when there's a DOL violation, such as under the Service Contract Act. That's an entirely different process, but does lead to a 3-year suspension debarment as well. But for our purposes here, you could see here the supplement talks about kind of the proceedings and the procedures for suspension and debarment in NASA. They talk about it as 2 distinct proceedings. First is matters opposition to the suspension or debarment by the contractor, and the second is kind of fact finding if there are material facts. If it's in a suspension action based upon an indictment or a proposed debarment action based upon a conviction or civil judgment, there is no fact-finding proceeding concerning the matters alleged in the indictment or the matters underlying the convictions or civil judgment. One thing to keep in mind here, if you look at suspension debarment in the FAR, it's not supposed to be a punishment. It's based on present responsibility of the contractor. So the most important thing with all of these suspension debarment proceedings is showing present responsibility by showing, hey, this may have happened in the past, but we're different now because we've done X. And these are the things that we're going to do to ensure that something like that doesn't happen again. And maybe even now, based on all these controls we have in place, we're better than your average contractor because we've done all these things. So it's hard because human nature wants to punish. The contractor's done something wrong, allegedly, resulted into an indictment, and the government personnel, and I've seen it. It's human nature. You guys have done bad. We're not going to let you do business with the government anymore. That's a privilege, not a right, and that's all very fair. But if you look at the regulations, and the NASA FAR supplement is not any different. It's not supposed to be about punishment. It's supposed to be about, is the contractor presently responsible to do business with the agency, with the federal government? And that's the lens that this is supposed to be viewed on. Let's go to the next slide. So conflicts of interest. Of course, conflicts of interest are always an important topic in government contracting in order to ensure that the space remains, it's important for the integrity of the marketplace that conflicts of interest don't occur, or to the extent that they are there, they're mitigated in some way, shape, or form. NASA has a great guide that talks through their conflicts of interests policies, and so you just search on the web for NASA Organizational Conflict of Interest Guide, and you'll see a lot of it. But one thing just to keep in mind, if there's a waiver of some kind, you look for the senior procurement executive as the approver for waivers. So that's all I'll really say about conflicts of interest, just because that in itself could be actually a full session. But you know, I think the way these are structured, I think, is terrific, because it helps you kind of issue spot. All right, what are the things I need to know, and then you can go and get further information from me or others, or whoever supports your work, or you do the research on your own. So one other thing that I thought was interesting here in this section is about support contractors. And you know, there are clauses that are out there, including in the DFARs, that require support contractors in the FAR to issue into non-disclosure agreements of some kind if they're viewing contractor information that they can use competitively. Then they're required to sign some kind of agreement to not do that. NASA here kind of takes that requirement away. You could see here the Assistant Administrator for Procurement has determined that it would not be in the government's interest to strictly comply with that FAR provision when acquiring support services for support management activities and administrative functions. So it's waived the requirement that before gaining access to another company's proprietary or sensitive information, that they must enter into some kind of non-disclosure agreement. So they will not require contractors and subcontractors to enter into separate interrelated third-party agreements to protect sensitive information. So then they have a provision that talks about what happens if there's an unauthorized breach. So what this is really saying is that, you know, there isn't an agreement. They're not going to force parties to sign an agreement. The plus side for contractors who are worried about their proprietary information being released is that trade secrets are protected whether there's an agreement to do so or not. There's an inherent agreement, but you do then have to go through the effort of establishing what was breached was a trade secret of some kind, or was proprietary of some kind. So it would require somebody who's alleging impropriety of that support contractor. It requires them to go through additional hoops from a legal standpoint, usually in most courts, when bringing allegations that proprietary information was taken and used in a manner that was not consistent with what was required. So just something to keep in mind, but it's there. Let's go to the next slide. So looking at section part 1812, you're looking at commercial contracting. And just like with the FAR and the DFAR and other agency supplements, they have certain clauses that are okay to put into commercial contracts. And this is always a kind of a moving target. We had the Section 809 panel a few years ago in efforts to streamline government contracting, tried to narrow down the clauses that would go into a government contract for commercial items or services. And there are regulations that are kind of pending out there right now, which would possibly do that. So remains to be seen if those regulations actually wind up being issued or not, or when, but it seems like that they're in the works. So you can see here, these are the different clauses that are authorized to be put into commercial contracts by NASA, separate and apart from the FAR, but their own regulations. And you can see right at the top there are the security and cybersecurity based clauses, obviously of importance to NASA. Next slide. Moving along to Subchapter C, which deals with contracting methods and contract types. So DoD had a preference for fixed price contracts that was rescinded in the most recent National Defense Authorization Act, the 2022 version. 2023 is in the process right now. Regulations are being issued to rescind that preference. Here, procurements under the simplified acquisition threshold, which is now $250,000, must be fixed price, as it says in the regulation. Also, they have a requirement that bids cannot be submitted by telephone. So not that folks are regularly submitting bids by telephone, but that's must be put to writing. There's a document called a notice of award, and it talks about the use of the notice of award and whether it's required or not. So just look at that section or this subchapter if you're curious about notices of award. Looking at section 1815.201, it makes agencies issue draft requests for proposals if the acquisition is expected to exceed $10 million. So it gives contractors an opportunity and the government opportunity to kind of see what the capabilities are and kind of craft what the final RFP is. LPTA, lowest price technically acceptable. We've had a bunch of new regulations in the FAR and the DFAR that have covered LPTA when it's appropriate to use. This talks about, essentially gives the NASA COs permission to use LPTA under certain circumstances. I would also look, if you get this and you don't want it to be LPTA, look to the FAR clause, and I haven't done this math, but see if there's agreement between this clause and the FAR clause, because you may have an argument to the agent, to NASA, about use of this clause, because the FAR and DFAR clauses have really narrowed the scope of when LPTA can be used and what kind of documentation is required. So if both clauses are in the contract, something to look at. Next slide. So when evaluating awards, which is something that folks on the contractor side are very interested in, what are the evaluation factors that NASA uses? Well, there is a regulation in this subchapter C talks to it. The 3 evaluation factors: mission sustainability, cost and price, and past performance. So you can see here they're developed by the source selection evaluation team and approved by the source selection authority. No surprises there. And they could be further defined by the subfactors. And just kind of the general stuff that you expect to see. All evaluation subfactors should be clearly defined in order to avoid overlap. Further subdivision below the subfactor level is prohibited. The biggest question, like based on terminology I had when I looked at this initially, not just now, but in the past, is what is mission sustainability? So I thought I'd put that in here so it's defined so you could see what it is. You can see it's the merit or excellence of the work to be performed or product to be delivered. It includes, as appropriate, both technical and management subfactors. It should be numerically weighted and scored on a 1,000-point scale. So all this is in that section here, 1815.304-70, and talks about those evaluation factors. There's a lot more detail than I have here, of course, in this slide, but it's, you're studying for a test in a way when you submit a proposal. The answer, you don't know the answers, but you know how they're going to grade you. So this provision, if you're submitting proposals to NASA, I think is essential reading. Also, the subchapter Part C talks about the different kinds of contracts that we find that NASA will issue. No surprises there really, for the most part. Next slide. Moving on to subchapter D, which talks about socioeconomic programs. First part here, not a surprise either. COs should seek certificates of competency before they find a small business is not responsible. SBA is the one who's responsible generally for issuing those. There's a procedure listed in the regulations that talks about what happens if there's a disagreement between SBA and NASA. So if you get in that position, there is some more than guidance regulations that speak to that. Also, in this category, the subcontracting plans, and NASA is not obligated to approve a subcontracting plan that was approved by another agency. And then they talk about their mentor protege program, the application, and you could see at the bottom of this bullet point what's supposed to be in an application, but the CO accepts the application. It's sent to the small business specialist at NASA Center, and these are the things that it must include. The application must include a signed mentor protege agreement, a protege application. You can see here the estimated cost of technical assistance to be provided, and any other information that NASA requires, and a signed letter of endorsement by the CO and the contracting officer representative. So interesting though, I haven't seen too much about this program, but it's in the regulations, so it's an option that contractors have when doing business with NASA. Next slide. So another part of this socioeconomic programs, where you find certain things is not always obvious. So you may want to, if you don't think that the NASA FAR supplement covers a topic, it's good to search even the document, even search the PDF using the search function, because here within the socioeconomic programs we have labor. So if you look at part 1822, it talks about labor. And one interesting thing about Service Contract Act collective bargaining agreements, the requirement for the successor contractor to pay the wages and fringe benefits is applicable until superseded by a new wage termination on the contract. So here, it's fairly consistent with what DOL requires in their regulations. So there are 4C, what are called 4C wage determinations. So if the contract was subject to a collective bargaining agreement earlier, and then you come in as a new contractor, and as a new contractor, you're unable to come into agreement with the union, you're supposed to still pay the wages and benefits, the monetary provisions of the CBA for the next contract period. Probably DOL's position is usually it should be at least a year. And that being said, if a new CBA is signed, then that CBA will take hold as long as it's properly inserted into the contract. Here, they talk about a new wage termination on the contract superseding the previous requirement. So the interesting thing is what happens if a NASA contracting officer, you're paying the wages and benefits from the previous CBA, and then a new regular area wage termination comes out, and the NASA CO issues a wage termination, puts it in your contract, even while you're still paying these higher wages and benefits potentially. How does that difference resolve? It looks like this regulation says you switch over, but DOL may not take too kindly to that depending on how long you've been paying the wages and benefits under the previous collective bargaining agreement. So I'd keep track of this if you're in that position. It's not something that happens every day, but it can happen. One great resource on the labor front in general, not just with NASA, but including NASA, are their agency labor advisors. And they're a great resource if you're having problems with implementation of SCA and Davis-Bacon Act or other labor clauses. When I say difficulties with implementation, maybe you're having a disagreement with the agency about whether it should be implemented and how, and the CO is not listening. Sometimes that agency labor advisor could be a resource, kind of a intermediary, even though they do work for the agency. Here, the agency labor advisor is the headquarters contractor industrial relations officer. Next slide. So we're looking at Subpart E, which are general contracting requirements. They have a very, not surprising because it's NASA, but they have a really extensive section on patents, copyrights, and data. So if you're playing in this field, I would really pay close attention. My read of the NASA regulations in general is that they're not as contractor friendly, for lack of a better term, when it comes to patents. So really pay close attention to that. I put the links in here as far as what you need to look at. You can see the NASA modifies the FAR clauses, so you should study these clauses carefully, especially dealing with patents. Look to the contract, as I always like to say. What is the contract giving NASA the right to? And it's obviously going to be dependent on who has developed that who has developed that work, and with what money? What's the color of the money that was used to develop the invention or the data or whatever it is that's worth protecting? But we could spend hours just talking about intellectual property rights and NASA contracts, but instead I'm flagging this. So if you are in this position, you can kind of look at these provisions because I think they're important to look at, and specifically look at Subchapter E and the statute 51 USC 20135. Also, if you look at CAS requirements, cost accounting standards, only the senior procurement executive within NASA can waive that. If you look at the definitions section, I talked about this earlier, you'll see who that senior procurement executive is. And interesting tidbit just about agency level protests. If you do file a protest with NASA, you should request that somebody, which is always good practice, somebody higher than the CO can review it. Otherwise, the CO will review the protest themselves, or herself or himself, unless the contractor asks for a higher level review. So obviously, if you're filing the agency protest, you probably want that higher level review. So be sure to specify that in that agency protest. Next slide. As we're kind of winding down here, Subchapter F, you can see the parts that are involved, talks about kind of specific types of acquisitions. And so if you might see this, you can see some examples of things, major acquisitions, service contracts, acquisitions of IT. There's other categories too, but if for certain types of acquisitions, they have specific clauses. These clauses won't be applicable in every circumstance, but they're there. So, just keep in mind, these clauses are in this section are not as comprehensive, but you can see that they're add-on requirements for FAR, just as they are elsewhere. But these are requirements that you have in addition to your FAR requirements if they're in your contract. Next slide. Contract management here. There's about 9 subparts in here. Just some highlights. You could see part 1842 talks about audits. Just as a FYI, DCAA does the audits for NASA. They're the cognizant agency for that. You could see if you want to modify a contract for an equitable adjustment, that's limited to 60 days. Talks about consenting to subcontracting in 1844. 1845 government property, very extensive section, as I noted here. So if you're dealing with government property, I think you'll find a lot of interesting information there. Just for issue spotting, just FYI. And then 1846, you can see quality assurance, and what happens if NASA becomes aware of fraud, malpractice, or other serious misconduct. And terminations. There's a different procedure for terminations in part 1849, so just take a look at that if you're in that position. Next slide. And if the clauses that you'll find in the contracts are here in Subchapter H. That contains all the NASA solicitation provisions. They should embody what we talked about today, and I did specifically go into the one on cybersecurity because I thought that was particularly relevant. But the ideas I think are more important to examine today. But you should know that Subchapter H, parts 1852 and 1853, have all the solicitation provisions and the clauses themselves. Next slide. And Subchapter I has additional agency supplemental regulations. They're actually fairly extensive. The ones that they have right now deal with flight investigations, just as an FYI. Next slide. And with that, I will pass it back to you, Madison. Thank you.
Thank you so much, Eric, for such a great presentation. Should you have any questions for Eric, his contact information is on the screen now. And as always, the recording will be available after this session very shortly. We'll be sending that out to you. You can also find past recordings on our YouTube channel and the PowerPoint on slideshare.net. And we really hope that we'll see you on Friday as we dig into the playbook on NASA. So thank you everyone for attending. Thank you, Eric, again. This concludes the webinar, and have a great rest of your day.